Hello and welcome to this discussion where we examine a recent order of the Supreme Court of India, which deals with the controversies surrounding the Adani Group, the Securities and Exchange Board of India, which is a regulator of India's capital markets, as well as recent reports that have been brought out by the OCCRP, or the the Organized Crime and Corruption Reporting Project, an international non-government organization, as well as the Hindenburg Research Report, which came out on the 24th of January 2023. These media reports, as well as the inquiries and the controversies which have gone all the way up to the apex court of India, have aroused a lot of interest. To discuss this subject, I'm very happy to welcome Prapti Banerjee. She has almost 2 decades of hands-on experience in the Indian corporate sector, understands the working of corporate laws. Thank you so much, Prapti, for giving us your time.
It's my pleasure, Paranjoy.
Okay, so on the 3rd of January 2024, the Supreme Court of India, a bench of judges, 3 judges, led by the Chief Justice of India, D.Y. Chandrachud, and comprising Justices J.B. Bhardiwala and Manoj Mishra, they came out with a 46-page judgment. Now, this judgment has resulted in some very, very predictable reactions. The supporters of the Adani Group saying, oh, this has been a clean chit to the Adani Group. Whereas others, independent observers, including economist Prasenjit Bose, who has written a detailed analysis of this judgment in the Hindu newspaper and website on the 5th of January, 2 days after the judgment, titled Decoding the Adani Hindenburg Judgment, he says, no, if the Supreme Court of India has sought to give anybody a clean chit, it is SEBI, the Securities and Exchange Board of India. So I'd like you to give a brief summary of how you see the Supreme Court judgment, and then we can look at specific issues that have been raised in that judgment.
See, first of all, he's right. If anybody has been given a clean chit, that is the Securities and Exchange Board of India. If anybody has to celebrate and congratulate themselves, that is the Security and Exchange Board of India, that's SEBI, not Adani by any means. And the question that was being discussed, the question that the judgment pertains to, has nothing to do with Adani per se. See, there were 4 petitions. 3 petitions out of 4 were talking about, they asked the Supreme Court for a relief, which was investigate the matter. That was the remedy they wanted. Okay. And there was one petition that talked about arresting Mr. Nathan Anderson and his associates because they
And
came
and
out with
and,
the
and
Hindenburg
Nathan
report.
Anderson he's the head of
He-
Hindenburg Research, which is a New York-based short-selling company. Yes, go on.
So, I mean, barring the fourth one, which does not make any sense, but anyway, the Supreme Court of India did entertain that petition as well. The Supreme Court clubbed these 4 petitions together, and what was the relief that these petitions wanted? What did they ask the Supreme Court to do? They asked the Supreme Court that an investigation had to be done on the Adani Group. Now, different petitions wanted the investigation in a different manner. One petition wanted that the Supreme Court should monitor this investigation, and this investigation should be done by a special committee which was headed under the supervision of a Supreme Court judge. That was
Yes.
one of the
So, so
suggestions. Another,
one of the suggestions was that it could also be done by India's
yeah,
premier police investigating agency, the Central Bureau of
which is
Investigation,
the CBI.
CBI,
Yeah,
or a kind of an
the central.
SEBI, a special investigating team under the supervision of a court or of a court appointed retired judge or
Yes.
someone like that. Yes.
So the court had to decide whether Securities and Exchange Board of India had to do the investigation, or it should be done by a special investigative team or the Central Bureau of Investigation or somebody else. So basically, that was the decision that the court had to make. That was the argument which was all about in this particular judgment, nothing else. So I mean, if the court had to decide that they had to take away the investigation from the Security and Exchange Board of India, which is the regulatory body for stock markets in India, and which has the jurisdiction of investigating such cases and adjudicating such cases. In this case, and it's a right and a duty which is given by the Parliament of India under the Security and Exchange Board Act. So it is the SEBI's, which is the Securities and Exchange Board of India, is their right as well as duty to carry on investigation in such matters. To
Okay.
take away such a right and the duty, the Supreme Court had to be extremely sure that SEBI is not doing its job properly, and there are some really big lacunae in this case, and hence SEBI will not be given this investigation any further, because SEBI has since March 2023, SEBI has been engaged in this investigation.
All right.
And
Let me stop you.
okay,
We can go back in time. There is a letter that was given by the then head of the Directorate of Revenue Intelligence to the then head of SEBI, Mr. U.K. Sinha, who incidentally happens to be currently the head of a media organization, NDTV, which is part of the Adani Group. Be that as it may, the question is we want to examine the role of SEBI. The Supreme Court judgment says 22 out of the 24 investigations in the Adani Hindenburg case has been completed. And then it notes that the Supreme Court has done nothing to interfere with these investigations or intervene in these investigations, and they have to be taken to their logical conclusion in accordance with the law. This is what the Supreme Court has said. Now, if you look at the status report that has been submitted by SEBI, and this was submitted on the 25th of August 2023, these 22 reports, 2 relate to manipulation of stock prices, 13 on failure to disclose what are called related party transactions, 5 on alleged violations of insider trading, and there are 1 each on violation of regulations pertaining to foreign portfolio investors and acquisitions, takeovers, mergers. The point to note, we don't know what these investigations, what they have yielded. No reports have been made public. So, can one conclude whether or not there has been regulatory failure? Now, the expert committee that was set up by the Supreme Court, what is their conclusion? What is the court's understanding of whether or not there has been regulatory failure? Should one accept the report of the Securities and Exchange Board of India at face value, or their claims or their contentions at face value without even knowing the details? Yes, Prapti.
so I'll start from the very beginning. When the Hindenburg report was released on 24th of January, after that, in February, the court took cognizance through petitions of the matter. and they decided that yes, there has to be an investigation. And in March, and in March they set up an expert committee.
Absolutely. 2nd of March. The 2nd of
Yeah,
March
yeah,
2023, the terms of
yeah.
references.
They set up so the Supreme Court decided to set up an expert committee. The mandate that was given to the expert committee is now. I'll just go back a bit. In February itself, when the matter of investigating the Adani Group arose, SEBI gave a submission to the Supreme Court that we have been investigating this group since 2020. So Supreme Court said fine, but then whatever you have investigated, when it has set up an expert committee, the committee had to look into what SEBI had investigated so far, whether there were any regulatory failures in such an investigation, whether there was a failure on SEBI's part in doing the investigation, and whatever SEBI was doing, whether it was on the correct course or not, as far as this investigation is concerned. Also, the regulator, the expert committee had to look at many other things, including, when Indian market is volatile, how much Hindenburg's report has affected the market, what are the investor education programs that have been
Whether
going
whether
on,
the
so on
whether
and
the
so forth, which is not.
whether the promoter group, who constitutes the promoter group, whether their shareholding has gone above the 75% threshold, who are these people who are part of the promoters, who are the beneficiary owners, who are the ultimate beneficiary owners. So all of these were some various things that had to be looked into.
Yeah, so the expert committee is not supposed to look into the matter where they are not supposed to find out who are the beneficiary owners or whether there has been a related party transaction or not. They were supposed to oversee the investigation that SEBI had done, and whether prima facie there was any evidence so far which suggested that Adani Group had engaged in related party transaction, or whether the promoters had a stake which was well over 75% of the permitted norms, so on and so forth. So whether there was a breach of law that had come out through any investigation at that point of time, that was the mandate that was given to the expert committee. The committee and SEBI, which is Securities and Exchange Board of India, they were both given 2 months' time to finish their investigation and come up with the report. SEBI was also supposed to cooperate with the committee so that the committee can figure out whether there has been a regulatory problem or not, whether SEBI is capable enough of investigating this matter or not. All right. So after 2 months, in May, the committee submitted its report, and the what the committee suggested was, uh, on various aspects of investigation, the Securities and Exchange Board of India had not really shown any breach of trust or any regulatory failure or any aspect which showed that they are not capable of carrying on the investigation on these matters. The committee gave its report. At the same time, SEBI was also supposed to finish its investigation and come up with its report. SEBI asked for extension from the Supreme Court at the same time, and it did give its logic of why there it would need extension, and what are the practical problems in finishing the investigation within 2 months.
Let me stop you here. Now the Supreme Court has said SEBI gets more time. And he says, try and complete the report. And it uses the word preferably within 3 months. Now, I
Yeah.
mean, if you go back in time, this investigation has been going on for a very, very long time. Now you have the expert committee that has already brought to light that there were 13 overseas entities having significant shareholding in Adani Group companies that were being investigated. Now it is saying the inquiry hit a wall. Then it is used a phrase that it has become a journey without a destination. Then it says how it is a chicken and egg kind of a situation. Why? We are seeing how the rules itself have been changed. SEBI itself in 2018 and 2019 have made several changes to the regulations pertaining to foreign portfolio investors. Who is a beneficial owner? Who is the ultimate beneficial owner? What is a opaque structure? These rules are itself being changed. So we are in a very, very complex and a muddy situation at present. Please explain for the benefit of those who are hearing you what is going on. To an ordinary person, this is all very, very confusing. Is SEBI protecting itself, or is it trying to justify why it is taking such a long time to complete these investigations when so much information is already in the public domain?
So, just briefly, when you talk about rules getting changed, uh, there is this Prevention of Money Laundering Act, which is a government of India act. It is not something which SEBI has any control over. So, when it comes to people who are investing money from outside India into India, the Prevention of Money Laundering Act comes into force. And as far as SEBI is concerned, the PMLA or the Prevention of Money Laundering Act actually pertains to the foreign portfolio investors. These can be funds, these can be individual investors, and foreign portfolio investors had to make some disclosures before they put in funds into the stock market or financial markets of India. And they had to make these disclosures to SEBI under the PMLA Act, which is the Prevention of Money Laundering Act. The SEBI derived its norms from this act itself. Now, when you say SEBI changed the rules, actually SEBI did not change the rules. The definitions under the Prevention of Money Laundering Act was changed by the government itself in 2014. So first of all, it's the government that changed the rules. Now, SEBI, because this is the genesis of these definitions were from the PMLA Act, SEBI changed its rules as well for a particular time being. From 2014 to 2018, the opaque companies, which means companies where you could not identify who is the person behind a company, these opaque companies, if nobody had more than 25% stake in the company, they did not have to. So basically, understand it in this manner that now, if you are the person who is behind the funds and you have appointed your driver as the your chef as the CEO, just an example, then you could the chef can be the front person. Nobody would know that Paranjoy is the person behind this company. All right. So the norms and the regulations were changed in a manner where the actual person could be hidden, and the face could be anybody who is an official appointee, who is a CEO. SEBI did change these rules in 2018-19, and there have been progressive changes in these rules, which have sort of deviated from the Prevention of Money Laundering Act. Now, as per SEBI, what it says is in 2018, it had made it mandatory for every foreign portfolio investors to make disclosures. Earlier, the norm was 25% stake in the fund minimum. Those who have more than 25%
Hmm.
stake, they had to be revealed. The threshold was brought down to 10%. So if anybody has 10% stake in a particular fund, they had to be revealed regardless of whether they are whether they are in a management position or not. These norms have in fact gotten tightened, which is true.
Let me read out to you two paragraphs from what Prasenjit Bose wrote in his article in the Hindu. And I'd like you to elaborate and explain this. He said that the report of the expert committee provided a very elaborate account on SEBI's successive amendments to the regulations on foreign portfolio investors that were made in 2018 and 2019, as well as the regulations pertaining to what are called listing obligations and disclosure requirements, LODRs. And these were all brought between 2018 and 2022. Now, these, according to Bose and Mr. Bose, and there are many others who have said this, these amendments eventually facilitated, as you have pointed out, the concealment of the ultimate beneficial ownership of these foreign portfolio investors. And therefore, according to him, they are violative of the Act, of the SEBI Act, which explicitly prohibits, and there are quotations here, contrivances and devices that are structured to bypass the law. Now, by the Supreme Court, according to Mr. Prasenjit Bose, has ignored the detailed critique of SEBI's regulatory actions. And it has only relied on what SEBI has said in its own affidavit, which was submitted on the 10th of July 2023. And therefore, SEBI is claiming that its use of the term opaque to describe the suspended foreign portfolio investors was mistakenly interpreted by the expert committee to imply that the rules are on opaque structures. Now, I can't figure out. I mean, who are you? Who misinterpreted what? According to Mr. Bose, this argument is an affront to the collective wisdom of the expert committee. What are your thoughts on this?
I think I mean, as far as the norms are concerned, about the disclosure norms are concerned, they have indeed been tightened uh, over the time. But at the same, and what SEBI is saying is also correct, that what it is saying is that you know even I mean, the opaque structure or not, I mean, as far as the SEBI's rules are concerned, uh, the problems with finding the ultimate beneficiary owner and proving whether they have any relationship with Adani Group or not of certain funds would still be as difficult if the rules were not changed, because these entities can have say less than 10% stake. They can have 1% stake in 100 of funds, and then consolidatedly they can have, say, a larger stake. And that is where they are finding it difficult to carry on the investigation at this kind of granular level. Now, what is happening here, Paranjoy, is that there has been I mean, prima facie, there has not been a breach of law, but the law itself has been twisted to a level which has given a playing field. So the playing field to people who can then take advantage of the twisted form of law.
Okay.
Now,
Yeah, yeah. Yeah, you know what Prasenjit Bose has alleged is that the SEBI itself has suppressed the fact that it, in its own master circular on anti-money laundering and combating financing of terrorism standards, which was issued in February 2010, they had a very clear definition of beneficial ownership. And what was that? He said the natural person or persons who ultimately own, control, or influence a client and all persons on whose behalf a transaction is being conducted. Now you have muddied the waters. You are saying the Adani Group hasn't violated the laws, but you have, to use your words, the rules have been twisted in such a manner that it is actually facilitated. the process.
Exactly. And if you see, I mean, the genesis is the government. It's not the SEBI. In fact, after this rule was changed in 2014, from 2014 to 18, it continued as it is in SEBI, and then it was changed gradually within the ambit of SEBI. And today, what SEBI has done is that it has gone even more granular, saying that if a foreign portfolio investor has more than 50% of its asset under management in a particular group, then it has to reveal each and every person who is involved in that fund. I mean, to that level. Or there are certain, benchmark amount of there are norms that if so much money has been invested, then you have to reveal each and every person. You have to identify each and every person regardless of the amount of stakes they hold in the fund. So gradually, SEBI has progressed to that level, and I will not I do not see uh, if the direction that SEBI has taken is correct. But at the
Okay.
same, having said that, I mean, no, yeah, you were saying something?
Yeah, I actually have two questions, two main points, because and I'd like you to, give me short answers because, for want of time, really. One is, there are different agencies of the government of India. I mean, look at in the Ministry of Finance itself. SEBI is one. You also have the Enforcement Directorate, which is supposed to enforce the Prevention of Money Laundering Act. You have the Income Tax Department. You have the Directorate of Revenue Intelligence. But these organizations are not working in close coordination with each other. They seem to be working on their own. And if the Supreme Court can't get them to work together, then how are you going to arrive at the truth? Whether or not the Adani Group violated the laws of this country.
Paranjoy, the fact of matter is whether whether I mean, a lot in Supreme Court depends on how the case is argued. And one of the things that I would like to point out is that the case that was argued on behalf of the petitioners was extremely weak. The points that were raised, now these are the points that we can discuss in a debate, and but this debate never took place in front of the Supreme Court of India. That's the problem. The points that were raised were they were already taken care of. You look at the judgment and you see what it says. Every lawyer knows that media reports prima facie will not serve as evidence. There has to be the evidence has to prove the media report. A media report cannot be taken as an evidence. That's there in all that's the norm. I mean, it will not be taken prima facie. So if the argument is that the Hindenburg report says so and so, or the OCCERP report says so and so,
Or the Financial Times
evidences
report.
have
One
to
minute.
be provided. Yeah.
Let me, 1 minute. SEBI wrote to the OCCRP asking for documents. Nobody is challenging the authenticity of the documents, mind you, whether it be the Hindenburg documents or the OCCRP documents or the Financial Times. OCCRP wrote and said the documents are with Advocate Prashant Bhushan. But SEBI didn't go to
But
Advocate.
that's not the way it works, Paranjoy. I mean,
No,
there
no,
has
one
to be
minute,
a
1 minute.
custody of evidence.
How should it work? How should it work? You're not questioning the authenticity of the documents, but then you're saying you can't depend on
But
these.
tell me one thing. What prevented Mr. Prashant Bhushan from presenting these evidences at the court? I mean, the court clearly said that these evidences are not. I cannot see the evidences. Now, if SEBI is not presenting, or
As
for,
far as I
I
know,
mean,
these
for
events,
some reason,
excuse me, as far as I know, all these documents were presented in the court in supplementary affidavits.
that's not what the judgment says. But I mean, See, what is happening is we know, I mean, what is going on is a charade in front of us. We know
What is it?
that the
You know,
Securities and Exchange.
no, you are making a strong statement. I asked you two questions. I asked you, the first is why the different agencies under the Ministry of Finance are not acting in coordination with one another. The second point I asked you is about the authenticity or otherwise of the documents presented in the media reports, including the association of Chang Chung Ling and his entities in Taiwan. He is a Taiwan based in Taiwan, and Nasser Ali Shaban Ali, who's based in the United Arab Emirates. And these individuals and the entities they control and the corporate bodies that they are associated with are linked to Vinod Adani, who is the older brother of Gautam Adani, who heads the Adani Group. I'd like you to
Paranjoy,
I'd like you to summarize your thoughts and give me your concluding remarks on what has happened.
what was the contention in the court? What was the basis of the petition? And what was actually argued in the court? In the court, on behalf of the petitioners, it was argued that SEBI is not competent. SEBI has irregularities because one, the rules were changed, which SEBI had already explained. The second, there was a DRI letter that was quoted, which SEBI had apparently not taken cognizance of. As it happened, Supreme Court, even there was the case was already done and dusted. There was nothing for SEBI to act upon, and Supreme Court had also given an appellate decision on this. Now, when you are going to the court and SEBI and saying that Securities and Exchange Board of India is incompetent because of XYZ, you don't argue those things which are already presented, where the case has already been presented. I mean, those arguments have to be something else. Now, if you are saying that the Securities and Exchange Board of India, there should be a special investigative team, the argument for special investigative team should include, ideally, that there is a money laundering angle to this, and which the Securities and Exchange Board of India cannot investigate. It does not have the jurisdiction. There are other angles to this. There are people like Chang Chung Ling or Shaban Ali. The Securities and Exchange Board of India will investigate only a part of it, which is the share market manipulation.
1 minute. We are going round and round. That is precisely what the Supreme Court have done. He said, SEBI, you can't do it alone. You need the support of the Enforcement Directorate, the Directorate of Revenue Intelligence, the Income Tax Department, and so on. That has not happened. And you yourself, you're using the word charade. What is the charade? Is SEBI not doing its job properly? What is the charade? It's taking a long time. And we don't know.
So, Paranjoy, the genesis of this problem is not just the share market manipulation, right? What has happened? There is a circular problem, right? Where there are allegations of money laundering and round tripping, where you know uh, importing goods at an escalated price, and hence sending money out of India. And then that money coming back to India via the share market route is a circular, is the circular route that the money that has taken. This entire Adani fiasco has multiple angles. It has got the angle of money laundering. It has got the angle of uh, you know mm, corporate governance, or the total lack of it within the company. And then there is the angle of manipulation of share markets via FPIs, where there has been breach of norms.
Prapti, I'd like you to summarize your views. I mean, there are several issues. As you have rightly pointed out, there are many dimensions to the investigation. There is this issue of over-invoicing. There is this issue of money laundering. There is this issue of violation of stock market regulations. And as we've discussed, what the Supreme Court could have done was ask the Enforcement Directorate, ask the Directorate of Revenue Intelligence, ask the Income Tax Department, and SEBI to work in close coordination with one another. Well, we haven't seen that happen. So where do we go from here? If you can explain the situation and what needs to be done from here.
So, Paranjoy, I'll speak from the point of view of law. There are many dimensions to the Adani fiasco. As you have also reiterated that there is money laundering aspect, there is aspect of stock market manipulation, there is aspect of irregularities with the foreign portfolio investors. All these things are there, but it has been beautifully boiled down to one aspect, which is the stock market manipulation, and the entire scanner has been put on the Securities and Exchange Board of India. I think this is where we are going wrong. Because when the laws have been changed to favor a certain party, you can put the regulator and nothing is going to happen. The second aspect is what is the relief that the court was sought after? What is the relief that the petitioners wanted? There had to be an investigation on the stock market manipulation. That was the relief that was sought. So the Supreme Court will not step beyond the ambit of the petitions. There have been no petitions, no questioning of the manipulation of the laws which has allowed a single group to actually dominate India. What we are seeing is a systematic takeover of India by a particular corporate group which has been facilitated by the government. The petition which are in front of the Supreme Court do not deal with all these matters. Talking about money laundering. They are not talking about corporate governance. They are not talking about inquiring into all these aspects. The only aspect that these petitions are talking about pertain to the stock market. And beautifully the scanner has been removed from the Adani Group and its wrongdoings, alleged wrongdoings, to what SEBI is doing, what the Securities and Exchange Board of India is doing. The board will act as per the regulations that are there in the market. Also, the Supreme Court will act as per the petitions that are filed in front of it. It will not go beyond that ambit.
Okay.
Now, my question is that there are all these aspects which have been highlighted in both the Hindenburg report, the Financial Times report, as well as OCCRP report. Many aspects of these reports have not been highlighted in front of the court. There has been no petition regarding this. The second is, as far as evidences are concerned, you do say that these evidences were put before the court. In the judgment, there has been no mention of these evidences which Mr. Prashant Bhushan has allegedly submitted. The judgment does not talk about it. The judgment clearly says, and I will quote it, the judgment clearly says, before concluding, we must observe that public interest jurisprudence under Article 32 of the Constitution was expanded by this court to secure access to justice and provide ordinary citizens with the opportunity to highlight legitimate causes before this court. It has served as a tool to secure justice and ensure accountability on many occasions where ordinary citizens have approached a court with well researched petitions that highlight clear cause of action. However, petitions that lack adequate research and rely on unverified and unrelated material tend to be, in fact, counterproductive. This word of caution must be kept in mind by lawyers and members of civil society alike. What is the
So, so
Supreme
this
Court
is
trying to say?
so this is what the Supreme Court has said. So, in other words, what you are saying, and if I can summarize your thoughts, the government and not just the SEBI, as well as the petitioners, need to do much, much more if the truth behind the various allegations pertaining to Adani Group companies, allegations of money laundering, allegations of over-invoicing, allegations of stock market manipulation are to be taken forward and a logical conclusion is arrived at. Would I be correct in summarizing your views in this manner?
Exactly. And at the same time, there has to be a concerted effort. I mean, there are people who are discussing this matter, and the discussion has been very beautifully bent to one particular regulatory agency
All right.
whose hands are tied by law.
Okay.
Now, there has been there are the opposition has been trying to say a lot of things outside the parliament. The opposition, the Congress party, is filled up with luminaries of lawyers. These are luminary lawyers. There has not been a single petition by any of these lawyers pertaining to the matters which are outside the ambit of
All
SEBI.
right. Okay.
There has not been a concerted questioning. So
Okay.
if you have to reach to a logical conclusion, you
Oh,
have to you have to be smarter. You know that the
okay.
system is manipulated.
Okay. Thank you so much, Prapti, for giving us your time and giving us your views on what is likely to happen or what needs to be done if the truth behind the allegations relating to companies in the Adani Group are to be found. Thank you very much for being with us on this program.